testing. Alright, Part 219 of Title 49, Federal Railroad Administration, Department of Transportation Control of Alcohol and Drug Use, Subpart A, General 219.1, Purpose of the Scope 219.3, Application 219.4, Recognition for the Foreign Railroads Work Testing Program 219.5, Definition 219.17, 219.7 with the waiver of 219.9, we're responsible for the compliance 219.11 with the general condition of the chemical testing 219.13 through 219.15 reserved, 219.17 construction, 219.19 reserved, 219.21 information collection, 219.23 railroad police, subpart B prohibitions 219.101 alcohol drug use prohibited, 219.102 the prohibition of the use of beef controlled substances, 219.103 the prescribed over-the-counter drugs, 219.104 responsive action, 219.105 railroad duty to prevent violations, 219.107 the consequence of lawfully refusable and unlawful refusal. Subpart Z post-accident toxicological testing, 219.201 events for which the testing is required, 219.203 responsible for the railroad's employee, 219.205 specimen collection and handling, 219.206 FRA active for the breath and test result, 219.207 fatality, 219.209 report of test and refusals, 219.211 analysis for the follow-up, and 219.213 unlawful refusal consequences. Subpart D testing for cause 219.300 with mandatory reasonable suspicion testing, 219.301 testing for reasonable cause, 219.302 prompt suggestion for the collection time and limitations. Subpart E identification of troubled employees, 219.401 a requirement for the policies, 219.403 voluntary referral policy, 219.405 coworker report policy, 219.407 alternate policy. Subpart F pre-employment test 219.501 pre-employment drug testing, 219.502 pre-employment alcohol testing, 219.503 notification records, 219.505 refusal. Subpart G random alcohol drug testing programs, 219.601 random railroad random drug testing and procedure programs, 219.602 the FRA administrative determination random drug testing rate, 219.603 participating in the drug testing, 219.605 positive drug test results procedures, 219.607 random drug alcohol railroad random alcohol testing program, 219.608 Federal Railroad Administration determined the random alcohol testing rate, 219.609 participation alcohol testing, 219.611 test results indicated of alcohol concentration procedures. Subpart H drug alcohol testing procedures, 219.701 standard for the drug alcohol testing. Subpart I annual report, 219.800 annual reports, 219.801 to 803 with the reserve, 219 subpart J of the record keeping the requirements, 219.901 retention for the alcohol testing records, 219.903 retention for the drug testing records, 219.905 access to facilities and records. Appendix A to Part 219 Simple Schedule of Penalties. Appendix B to Part 219 Designation Laboratory Post-Accident Toxicological Testing. Appendix C to Part 219 Post-Accident Testing Specimen Collection. Or subpart A, 219.1, purpose of the scope. The purpose of the part is to prevent accidents of the casualty railroad operation with the result of the impairment of the employee for the alcohol or drug of the railroad and parts of the described the minimum federal standard for the control of the alcohol or drug use for the part that does not restrict the railroad of adopting and enforcing additional more stringent requirements of not inconsistent with this part. Application general accept that is provided in paragraph DSC with the section that parts apply with the railroad that are operating the rolling equipment standard gauge track with which are a part of the general railroad system of the transportation railroad to provide with the community or other short haul passenger services, metropolitan suburban areas described in Title 49 U.S. Standard Code 2102 of the United States. Exemption available to both the domestic and foreign railroad. The part does not apply with the railroad operating only the track inside of the installation, which is not part of the general railroad system of transportation. Subparts D, E, and F and D, E, F, G of this part do not apply with the railroad that has the total 15 fewer employees who have covered with the hours of service of Title 49 U.S. Standard Code 21103, 2114, 21105 would be subject to the hours of service of Title 49 U.S. Standard Code 21103, 211104, 21105. If the services were performed in the United States, does not operate with the tracks in the United States and another railroad, and otherwise engaged in joint operates for the United States and with another railroad's access for the necessary purpose of the interchange. Subpart 1 parts does not apply with the railroad with fewer than 400,000 total employees, including however the work with all the employees for the railroad, regardless of the occupation, only when the United States, but also with the outside of the United States. For the purpose of paragraph term, an employee for the railroad includes the individuals performing service of the railroad, include not only the individuals who directly receive monetary compensation for the railroad for performing service of the railroad, but individuals employed for the contract for the railroad where the performance services for the railroad. Exemption available to foreign railroads only. The subparts E, F, and G of the part do not apply with the train dispatching service of the United States performed employed with the foreign railroads, primarily the reporting point of the United States outside the United States are on the portion of the rail line with the United States exceeding up to 10 route miles from the point of the line with the crosses of the United States and Canada and Mexico. Unless otherwise provided in paragraph B of the section subparts A, B, C, D, E, H, I, J, and that are part with the supplies single services for the United States for the foreign railroad performed by an employee of the foreign railroad if the employee's primary purpose of reporting located on the outside of the United States subpart E, F, and G for the subpart does not apply with a single service for the United States foreign railroad performed then for the employee of the foreign railroad with the employee's primary purpose of reporting is located outside the United States. Unless otherwise expected within paragraph C1 of the section on and after June 11, 2004, the foreign railroad should conduct pre-employment and drug testing on each of the final application for each of the employees seeking to transfer the first time of the duties involved in the train dispatching in the United States while having his or her primary reporting point outside of the United States. The test shall be conducted in accordance with the part prior to the applicant employee's performance training of the dispatch service in the United States. 219.4 Recognition for the foreign railroad workplace testing. Journal of Foreign Railroad may be petitioned from the FRA Associated Administrative Safety Recognition for the workplace testing program promulgated under the laws of the home country with the comparatively alternative return to service requirements in subpart B of this part. The requirements of subpart E, F, and G of the part will respect for the employees who primarily report or outside of the United States but who are entered the United States performing the train dispatching with respect for the final applications or employees seeking the transfer of the first time duties involving in such service. 1. To be considered for the petition, most documents of the foreign railroad workplace and testing program contains the equivalent of subparts B, E, F, and G with the part pre-employment drug testing, a policy with the co-worker self-reporting alcohol, drug abuse problems, random drug alcohol testing, terms of duty testing procedures, safeguard, responsible, carable, the effectiveness applicable to provision of the United States Department of Transportation procedure, workplace drug alcohol testing, part 40 with its title. In approving the program under the section A for Associated Administrative Safety may impose the conditions testing deemed necessary, and B, alternative programs upon the FRA's recognition for the foreign railroad's workplace testing programs compatible with the return of service requirements subpart B with the requirements of subpart E, F, and G of the part. Foreign railroad must comply with either the enumerated provisions of part 219 with the standards of the recognized of the program and imposed with respect to the employees of the primary reporting point outside of the United States who perform the train dispatching or dispatching service of the United States. The foreign railroad must also, with respect to the final applicants for its employees seeking to transfer for the first time the duties involved in such a train dispatching service of the United States comply with either the part E, subpart E of the part of the standard for the recognition of the recognized program. Foreign railroad must comply with subparts A and B with the return of service provision in 219.104 D and C with the responsible section testing subpart D and subparts I and J. The drug alcohol testing required for these parts must conduct with the compliance with the applicable provision for the United States Department of Transportation procedure work drug alcohol testing program petition recognition for the foreign workplace testing program. Each petition recognition for the foreign workplace testing programs will contain the name of the title, the address, telephone number, the primary read of the contact with regard to the view of the petition, the requirements for the foreign railroad workplace testing program considered recognition operation. Appropriate data for the record for both the FRA considered with the determined with the foreign railroad workplace testing program equivalent to the minimum standard of the contained with the part with the provide with at least with the equivalent level of safety. The Federal Register notice for the FRA will publish a notice that Federal Register concerned with each with the position under the paragraph of each section C. Paragraph C of section section that it receives a comment no later than 30 days after the day of the publication notice of the Federal Register concerned with the position under paragraph C of this section. Any person may comment to on its position. Comment shall set forth and specify with the basis upon which it was made with contain the concise statement of the interest of the commenter to the in proceeding. Any comment on a petition should be referenced to the FRA docket and notice the number of the commenter may submit the comment related to the material only with one of the following Federal Rule Regulation Portal, Federal Rule Making Portal with the regulations that govern following the instructions made with the comments of Federal Docket Management System Electronic Docket Set. Fax 1-202-493-22-151 mail to the U.S. Department of Transportation Docket Operations M30 West Building Grounds Floor with the room 412 W12 140 with 1200 New Jersey and Southeast Washington D.C. 205900001 for hand delivery room 412 140 with the ground floor of West Building 1200 New Jersey Avenue Southeast Washington D.C. between 9 a.m. to 5 p.m. the Monday through Friday except for the federal holidays. The commenter shall certify the copy of the comment served within the petition. Note that all the petition received will be posted without change with the regulation of the government, including the personal information provided with the disposition of the petition. The FRA found that the petition comply with the requirements of this section of the Foreign Railroad Workplace Testing Program compatibility minimum standard for this part, but the petition will be granted normally within 90 days of the receipt. The petition is neither granted nor denied within 90 days. The petition remains pending for the decision. The FRA may attach a special condition for the approval of any of the petition. Following the approval of the petition, the FRA may reopen the consideration of the petition for the cause. 2. That the FRA finds the petition does not comply with the requirements of the section that the Foreign Railway Workplace Testing Program is not compatible with the minimum standard for the petition will deny normally 90 days after of its receipt. Whenever a grant of the denied potential reports consideration petition written notice is sent with the petition with the interested party program recognition of the program has been recognized with the Foreign Railroad should maintain a letter of the file indicating that it is elected to extend specified elements recognized with the program operation in the United States and other granted that once granted but the recognition remains valid so long that the program retains the elements of the Foreign Railroad comply with the program requirements. 219 definition for the act. If used in this part, accident incident reportable under the statute 225 does not include the case of the classified cover the data under the 225.5 with the chapter of the employee with the injury, illness caused for the reportable exclusively because of the physician or other illness, healthcare professional, either with a made one-time topical application, prescription, strength, and medication for the employee's injury made with a written recommendation that the employee take one more day away from the work when employed instead of the reports of work would have the report that he or she had been scheduled to take no day of the work into the connection with the injury or illness. Works restricted duty for the one or more of the days for the employees instead of the work unrestricted or would have the unrestricted he or she has been scheduled to take no other days restricted. Work activity in connection with the injury or illness take over the counter medication that the dose is equal to greater than minimum the prescription strength whether or not the employee actually takes the medication. Class 1, Class 2, Class 3 have the meanings assigned with the regulation with the Transportation Board Title 49 to 1201 the general instruction of the 1.1 the control substance for the meaning of the assignment with the Title 21 U.S. Code 802 and includes the substance listed in Schedule 1 through 5 as they may be revised from time to time. Title 21 CFR Part 1301 through 1316. Covered employee means a person who has been assigned with the performance of the service of the United States subject to the hours of service laws and Title 49 U.S. Standard Code Chapter 211 during the duty of the tour whether or not the person has performed current performance such for the service any person that performs such service and employee is not covered within. Meaning of the part of the exclusively reason for the employee with the pursuant to Title 49 U.S. Standard Code 21106. The purpose of the pre-employment testing only to cover the employee includes the person applying with the performed covered service of the United States. Covered service means the service of the United States subject to the hours of service of the law Title U.S. Standard Code 21103, 21104, 21105, but does not include the period of employee relieved of the responsibility period to come to go with restriction. Co-worker means that another employee with the railroad, including the work supervisor directly associated with the yard and train crew, such as the conductor, the yard foreman, but not including other railroad supervisors and special agent officers. Cross-border operation means the railroad operation across the United States and Canada and Mexico. Domestic railroad means the railroad that is incorporated within the United States. The agency means the agency of the operating administrative of the United States Department of Transportation Administrative. The regulation the requiring alcohol controlled substance testing. Title 14 CFR 61, 63, 65, 121, 135. Title 49 CFR 199, 219, 382, 655 in accordance with the Part 40 of its part. Drug means a substance other than alcohol that has not been made with the function altering effect for the human subject specifically including any physical activity substance including but not limited to the control substance for the one railroad means the railroad that is incorporated outside of the United States. FRA means Federal Road Administration, U.S. Department of Transportation, Federal Road Representative that means for the Associated Administrative Safety of the FRA Associated Administrative Delegate including qualified state inspector acting on Part 212 of the chapter. Chief Counsel for the FRA with the Chief Counsel Delegate General Railroad System. Transportation means the General Railroad System, the transportation of the United States. Hazardous material means for the commonality of the design with the hazardous materials parts 172 for the title. Impact for the accident means the train's accident with the railroad equipment the accident involved with the damage of success for the current reporting threshold of the chapter consisting of head-on collision, rear-end collision, side collision, including collision of the railroad crossing of the grade, switching collision, impact with deliberate placed on obstruction with the such within bump post, following or not impact accidents. Any accident in which the derailment of the equipment that could cover the impact of the rail equipment, impact the rail equipment, the obstruction of such as the falling trees, rocks, or snow slides, livestock, etc., racking, conclusion caused by the derailment of the rolling stack of operation of equipment, the violation of the clearance, limitation, the independent With the respective medical facility mean under the owner of the ship of the control of the railroad, not cooperative with the staff of the salaried officer employed over the railroad, the fact that the railroad paid for the services with the running of the medical facility laboratory circuit, select for the intent entity with the performing the test under the part of the standard contractual relationship with the entity of the performed test under this part of the perform the other medical examination or test or railroad employee does not intend itself to remove the facility from the definition. Medical facility means a hospital or clinic of physician's office, laboratory with a toxicological specimen that can be collected in accordance with the recognized professional standards. Medical practitioner means the physician, dentist, or licensed otherwise authorized practice in the state. Non-controlled substance means any substance including prescription medication, over-the-counter drug with dietary supplement, herbal preparations, which are not currently regulated in Untitled 21 U Standard Code 3801 through 971, Entitled 41 CFR 1308. NTSBs means the National National Transportation Safety Board. Passenger train means the train transporting persons other than employees. Contracted person riding equipment that preserve for the Boundary Railroad operation the intercity passenger for the commuter over the shore haul service, excursion for the recreational purposes. Positive rate of the random drug test means the number of the verified positive result of the random drug test conducted with under this part of the plus of the number of the refusal of the random drug test required with this part divided by the total number of the random drug test results. Positive, negatives, and refusals under this part possesses means to have one person and one person affects under the one's control have with the concept that possession also you the part does not include the control of the virtue of the presence of the employee, personal residence for the other similar location without the railroad property. Railroad means any form of the non-highway ground transportation that runs on the rail of the electromagnetic guideways. Any person provided the transportation, including commuter, other than short haul railroad passenger service, metropolitan suburban area commuter railroad service, operated with the Consolidated Railway Corporation on January 1st, 1979. High-speed ground transportation made the connection metropolitan area with regard with the system of the new technology associated with the traditional railroad that does not include the rapid transit operation in the urban area that do not connect with the general railroad system of transportation. Railroad property damage. Damage to railroad property refers to damage to railroad property, including the railroad on track, the signal, the track of the track structures, including the bridge and tunnel of the roadbed, including the labor over the cost of all other costs of the repair, the replacement, and kind of the estimated cost of the replacement of the railroad property may be calculated, described in the FRA guideline for preparing accidents, incident reports of statute 2521 of the chapter. However, the replacement of the passenger equipment is calculated based on the cost of acquiring new unit with a comparable service. Reportable injury to mean for the injury, reportable to part 225 of the chapter, except for the injury classified and covered to have the 225.5 of the chapter, the employee for the injury or illness, reportable exclusively because of the physician or other licensed healthcare professional, either based on one-time topical application of the prescription strength identification. Employee for the injury had the written recommendation that the employee would take one more of the days from work then, when the employees instead of the repeated reports for the work, and he or would have been reported that he or she has been scheduled to take those days away from the work in connection with the injury or illness. Work restricted the duty for the one more day for the employee instead of the work or restricted the other works have them work done restricted to he or she that has been scheduled. He takes no other days restricted to work activity in connection with the injury or illness. Take over the counter medication with the dosage equal or greater than the minimum prescription strength, whether or not the employee actually takes the medication. Reporting threshold means the amount of specified in 225.19E with the chapter of the sign adjusted for the time and in time in accordance with Appendix B with the start 225 with the chapter state with the means of the state of the United States of the State of America, District of Columbia. Supervisor employee means an officer, special agent, or other employee railroad who is not co-worker responsible for supervising, monitoring, and conducting the performance of one or more employees trained, except for those contexts required for the meaning of the locomotive or more than one locomotive coupled with or without cars. If the locomotive is self-propelled unit equipped that can be used with the train. So for the train accident means the passenger freight work train accident described in statute 225.19C with the chapter of railway equipment incident involving the damage except for the current report with the threshold including the accident involving the switching of the movement. Train incident means an event involving the movement of the railroad on the track of equipment is resulted in casualty, but which the railroad property does not exceed the reporting threshold. The United States means that all the safe, the violation rate of the random alcohol testing means the number of the four hundreds of and above of the random alcohol, 0.04 of the random alcohol confirmation test is 8. The result of the conducted under this part with the number of the refusal of random alcohol test required with this part divided and total number of the random alcohol screening tests, including refusal conducting under this part. Alright, 219.7 the waiver. The person subject with the requirement of the part made with the petition for the FRA with the waiver of the compliance of the requirements each position of the waiver. This section must be filled with the manner of the information required in part 211. The chapter of the position waiver the part of the 400 of part 40 with the prohibitions against the stand down of the employee made from before the medical review of the officer complete with the verification must also comply with the statute 4021 of this title. If the FR administrative waiver the compliance in the public interest is consistent with the railroad safety administrative with the grant the waiver with the necessary conditions, special dispositions of the employees performing the train dispatching services existing cross-border operations, the foreign railroad that request for the waiver not later than August 10th, 2004, the existing cross-border operations, subpart E, F, and G for this part shall not apply with the train dispatching on that the operation in the United States performed the employee with the foreign railroad whose primary reporting a point of the outside of the United States unit until the railroad waiver the request is acted upon the railroad. Where the waiver request the employees performing the train dispatching the service for the new expanded cross-border operation, the foreign railroad typically given the waiver of subparts E, F, and G for the part for its employees performing the train dispatching the service with not new cross-border operations to proceed more than 10 route miles into the United States. For example, formally accept that the cross-border operations expand between the 10-mile limit of the exemption of the paragraph D of the section must file with the permit petition no later than 90 days before the commencing subject to that operation. The FRA will attempt to decide with such petition within 90 days. If no action is taken on the petition within 90 days, the petition remains pending for the decision. Cross-border with the assignment with the operation covered with the petition will subject to the E and FG until the FRA grants the petition should the petition comments for the proposed operation. 219.9. Responsible for the compliance. Any person in any type of the covered in the U.S. Standard Title 1, including but not limited to following the railroad manager, the supervisor, official employee of the agent, or the owner, or manufacturer, leaser, or left for the railroad, equipment, the track of the facility, independent contractor, providing goods and services of the railroad, with the employee with trust for the owner, manufacturer, leaser, or left for the independent contractor, who violates the requirement of the part of the violation, such requirement is subject to civil penalty at least $650, no more than $25,000 per violation, except for the penalties may be accepted for the individual against an individual only for the willful violation, where the grossly negligent violation apparently the repeated violation has created an imminent hazard for the death or injury. He has caused death or injury. The penalty not exceeding $105,000 per violation may be accepted for the standard liability will vary depending upon the requirements involved with the e.g. the 219-105 of the will. Which must be construed with the qualified responsibility of the railroad for the unauthorized conduct of the employee of the violation 219-102 and 219-102, 101 and 2-102 with the employee for the due diligence preventing the such conduct each day of the violation continues to separate dependency appendix A of this part for the same agent for the penalty policy B1 within this case for the joint operation primarily responsibility compliance within the part with respect to determination of events for the qualifying breath or body fluid testing substance of CD for the part result of the host railroad all effective employees with respect to the direction of the host railroad consistent with this part however noting paragraph B1 restricts the ability of the railroad to provide appropriate assignment with the responsibility compliance with this part among the railroad through the joint operation agreement with the binding of the contract the FRA reserved the right to bring the enforcement action for the non-compliance with the applicable portion of the part with against the host of the railroad employee the repair road or both, employing railroad or both. When the employee one of the railroad is required to participate in breath or bodily fluid tests at subpart C or D with this part subsequent subject to the adverse action alleged for the horizon outside the required test alleged refusal thereof, necessary witness the documentation available to other railroad must have made available to the employee with a reasonable basis. Any independent contractor or other entity perform the coverage of the service of the railroad the same with the responsibility of the railroad under this part. With respect to the employees perform the coverage service of the entity responsible for the compliance with the department may be fulfilled with each of the directly and indirectly of the railroad treatment of the entity's employee through performing the coverage service so that they were owned, that it was its own employee for the purpose of the department responsible for the compliance must be clearly spelled out with the contract between the railroad and other entity without any other document in the absence of such clear delineation of the responsibility of the FRA will hold the railroad and other entities jointly severally liable for compliance. June 1911, general condition for the chemical test. Any employee with the performance of the covered services for the railroad deemed with the consistent with the testing for the required in subparts B, C, D, and G for this part, the consistent with implied performance. Such services each of those employees must participate in such testing as required under the conditions set forth in this part with the representative of the railroad. In a case where the employee is sustained with a personal injury subject to alcohol, drug testing under the part necessary medical treatment that must be accorded with the priority over the provisions for the breath and body fluid specimen to remain available, allowing the accident with the casualty required with the company rules being the absent without leave, considering the few refusals to participate in testing without the regard for the subsequent provision specimen. A covered employee who is required for testing subpart C of the D of the part is taken from the medical facility observation treatment of the accident incident deemed for the consent with the release of the FRA following the remaining portion of the body fluid specimen taken for the treatment of the facility within 12 hours of the accident incident that is not required for the medical purpose together with any normal medical facility record pertaining to taking such specimen, the result of any of the laboratory testing, alcohol or drug conduct or treating the facility of the specimen, identified dose at the time of the administration of the drugs administered of the treating facility prior to the time specimen were taken with the treating the facility or prior time that the specimen were taken in compliance with this part, the result of any breathing test for the alcohol to conduct for the treatment of the facility and employee required for participating with the blood testing fluid on the subpart C with the part post-accident toxicological testing. The testing subject of the subpart H for the part shall be the request of the representative of the railroad medical facility, including under subpart H for the part non-medical content tractor collected with the evidence consistent with the taking of the specimen, the relief, the toxicological analysis, the provision of the provision for this part of the relief, the test result of the railroad medical review officer promptly executing consistent with the reform of the required for the medical facility employee with not required to execute the document clause waiving the rights of the employee with the otherwise have against the employer with the such the waiver is void of the employee not required to waive the liability respect for the negligence of part of any of the person participating in the collection, handling and else specimen identifying with any of the person negligence other than inconsistent with the provided consistent with the section may be construed and extended only to those actions specified in section. Nothing in this part of the construction is authorized for the use of the physical coercion or other deprivation of liberty in order to compel the breathe or blood fluid testing. After any railroad employee performs services of the rail deemed to have the consent with the removal of the body fluid tissue with the specimen necessary to toxicological analysis of the remains such of the employee if the employee dies within 12 hours of the accident incident described in subpart C with the part result of the such event with the consistent with the specifically required but the employee is not covered in the service was also employed in the covered service. Each supervisor responsible for the covered service except for the working supervisor. The definition for the core worker under this part must be trained and signed with the system of the alcohol, drug and influence intoxication issue with consistent with the program and the instruction that made available for the inspection upon the demand of the FRA such for the program at the minimum to provide with the information concerning the acute behavior of their parent with the psychological effects of the alcohol or the major drug problems on the controlled substance to lift. The program must also provide training with the qualifying criteria of the post-accident testing contained in subpart C with the part with the role and supervisor post-accident collection so described in subpart C of the appendix C with the duration such that the training may not be less than 3 hours. Nothing of the subpart restrict the discretion and availability of the request required of the employee, the corporate and additional blood fluid test. However, no such testing may be performed on urine blood specimen provided under this part for the purpose of paragraph H of all urine from all void constitute a single specimen. A railroad required to authorize to conduct testing of the part may be conducted all such testing with the United States Foreign Railroad required to conduct the testing under this part may be conduct such tests in its own country provided that is otherwise complies with the requirements of this part. Alright, 219.13 through 219.15 reserved. 219.17 construction. Nothing in this part restricts the power of the effort to conduct the investigation under the section of 20107, 20108, 211, 111, 20112, and Title 49 U.S. Code creates a private right of the action of the part of the rating with the reason for the enforcement of the provision with the part of the damage result with the non-compliance with this part impact the provision of the state criminal law with the impose the sanction for the reckless conduct with lead to actual loss of life and injury damage to property, whether the provisions apply with the specific life of the railroad employees or generally that the public at large. 219.19 reserved. 219.21 information collection. Information collection requirements for this part must be reviewed by the Office of Management Budget pursuant to Paperwork Reduction of Act of 1980, the Title 40 U.S. Code 3501 intent sequence, and have been assigned by the Office of Management Control number 213000526. Information collection requirements are found in the following: 209, 723, 104, 201, 203, 205, 207, 209, 211, 213, 303, 401, 403, 405, 407, 501, 502, 503, 601, 605, 701, 801, 803, 901, 903. Or 219.23 Railroad Police. Whenever the breath of the body fluid is required for the employee under the part of the railroad, provide with the clear and unequivocal written note of the employee with the test is being required with the FRA regulation. The use of the mandate of the job form of the drug alcohol testing specifies the requirements of the paragraph A. Whenever the breath of the body fluid is required for the employee under this part of the railroad, must provide with the unequivocal written note of the basis which upon the test is required with reasonable suspicion violation specified the operating safety rule enumerated in some of the G part D of the department, the random selection follow-ups, etc. Completion of the alcohol drug testing and indicate the basis of the test prior to providing the copy of the employee satisfied with the requirements of the paragraph B of the use of the dot form of the non-federal test for the prohibited Use the approved form of the mandatory post-accident toxicological test under the subpart C of the part provides the notification owner for the required owner with section respect for such tests. Those forms over any other test is prohibited. Each of the railroad must provide educational material that explain the requirements of the part of the railroad policy procedure for the respect of the meeting of those requirements. The railroad must ensure that the copy of the materials distributed to each of the covered employee prior to the start of the alcohol testing and under the railroad's alcohol misuse prevention programs. Each person subsequently hired and transferred to cover the position. Each railroad must provide with written notice to represent with the employee organization availability information required. Contact the material that may be available to the employees must be included. These all decisions in the following: they identify the person with the designated name of the railroad. They answer the employee's question about the material, the cost of the craft of the employees are subject to the provision of this part. Sufficient information about the safety sensitive of the function performed by the employees to make clear. Periodic work of the day covered the employee required in compliance with the part of the period when the employee to do the required to perform and available to perform conformed services. Specific information with the concern with the employee connect with the product of the subpart B. In this case, the railroad utilization accident incident rule violation responsible for the cause of the testing authority provided with the part per notice of the which is combined with the notice of the required of the statute 219-601D with the 607D East 1 with the covered employee the circumstances under which they are subject to testing. Circumstances under which the covered employee will be tested under this part of the procedure will be used to test in the presence of the alcohol control substance partake of the employee with the integrity of the testing process, the safety of the guard, the validity of the testing result, ensure those that the result was attributed with the current employee. The requirements for the covered employee submit the alcohol drug test and administer the accordance with this part of the explanation with the constitutes the refusal to submit the alcohol drug testing attended with the consequences. The consequences of the employee found is violated subpart B of this part, including the requirement of the employee B moved immediately from the covered services in the procedure for the 219-104. The consequences covered the employee is found to have the alcohol concentration of 0.2 with a greater or less than 0.4. The information concerning the effect of alcohol misuse the individual health worker, the professional life, the signs and symptoms of the alcohol problem, and the employee of the co-worker is available. The method of evaluating and resolving the problem associated with the misuse of alcohol, including the utilization procedures set forth in subpart E of the part of the name, the address, the telephone number, the substance abuse for professional subject counseling treatment programs. F. Optional provision of the material supplied by the employee that may include the information additional railroads with respect to the use of the possession of alcohol drugs, including any consequence for the employee found to have the specific alcohol concentration that is based on the railroad authority independent of the part of this part. Any such additional policies or consequences may clearly describe being used as an independent authority. Subpart B. Prohibitions.